It's just an arrangement whereby real property is conveyed to a trustee while reserving the control benefits to the beneficiary. So if you've ever heard of property described as a bundle of rights, this is a good example of a bundle of rights. We're splitting the bundle up. That's what we're doing with the land trust, okay? The trustee is the one who owns legal and beneficial title, or equitable title, excuse me, legal and equitable title. They're the ones who actually are interested in the land records, okay? They're the ones who hold the title to the property. So when you have it, when you see a deed, it's going to be to Joe Schmo, trustee for the 123 Main Street Land Trust. And that's the trustee. The grantor is the creator of the trust. Typically, they're also the beneficiary. All right, they're the ones who own the beneficial interest in the trust. Beneficial interest in a trust is not legal title. It's not equitable title in a common law land trust either. It's personal property. Okay, that's extremely important. This whole legal equitable title on one hand, personal property thing on the other. We'll see the ramifications of that as we go along. But I want to highlight that for you right up front. This is crucial to understand. Legal title is the person you think of when you think of I own the property, you own legal title. Okay? Equitable title is when if you're a wholesaler, you have the right to get legal title to the property. Okay, you have the property under contract, something like that. That's equitable title. I have the right to obtain legal title of the property. As a beneficial owner, I'm not vested with legal title, so I don't own the property. I don't have equitable title either. I have a personal property interest in the land trust. Okay, crucial distinction. However, I do have, going back to the bundle of rights analogy, as the beneficial owner, I do have the rights to the benefits of the land trust. Okay, I can control the trust. I can control the property. I can direct the trustee to do whatever it is they're going to do with the property. I have the rights to earnings, the benefits, possession, and so on and so forth. Okay? The trustee in this case is purely ministerial. They do only what the beneficial owner commands them to do. That's it. They don't have any liability. They're a trustee. They don't want to do anything other than when you sign as beneficial owner a direction to the trustee saying, yeah, do this, trustee, sell the property, rent the property to this person, etc., etc. That's what they're going to do, and that's all they're going to do. Okay? So far, so good. I don't want to get too much in the weeds with equitable title. It is a complicated legal thing, but suffice it to say, we will be back to that. So, back to land trust. In Maryland, inter vivos revocable grantor trust based in contract and common law, rather than statutory. There is a statutory business trust in Maryland. We'll talk about that later. But this is common law. Common law is decisions of course over time. That's what common law refers to, as opposed to statutory law, which is the legislator enacting a statute. Okay? It's a contract. The land trust agreement is just a contract. It's between the trustee and typically the grantor / beneficial owner. Okay, so that's what creates the land trust. We want to put a deed into the trust itself, and then we have the trust agreement. Those are the two prerequisites to forming your land trust. You can amend it, change it, revoke it, terminate it at will. You don't have to do anything. Gorgeous thing about it, it's completely under the radar. You don't have to file, unlike an LLC, you don't have to file a registration statement, you don't have to pay anything. You're going to form it at the settlement table, typically. Form it at the settlement table, right there. Just sign the document. That's it. You got a land trust. You're good to go. Incidentally, I want to come back to something. Land trust is not an entity. Okay, it's just an arrangement. When you think about entities, they are LLCs, C corporations, S corporations, limited partnerships. These are all entities that are recognized by the state, by an enabling statute, as it were. Okay, a land trust is not an entity. It's just an arrangement. You're conveying title to a trustee. A trustee is holding title for the benefit of, in this case, beneficial owner land trust. Okay? Disregard for tax purposes, you don't even have to file a tax return. In the case of a LLC, you're going to have to file a 1065 if it's a partnership. You've got two beneficial owners. In land trust, you don't have to do that. Beneficial owners are responsible for their own taxes. That's it. So it really, truly is undercover. All you need, as I mentioned, is a trust agreement and a deed into the trustee. One thing, note there, sometimes people get a little tricked up. You can't have the same person be the trustee and beneficial owner, because then a merger happens. In other words, everything gets consolidated. And so what you want to do is have a trustee and beneficial owner different. You can have one person be the trustee and then two beneficial owners. You can have an LLC be the beneficial owner and a person be the trustee, etc. Just as long as you create some sort of dichotomy there. Just can't be completely uniform the same. Rule against perpetuities and statute of uses. These are important things if you really want to drill down a little bit. The rule against perpetuities is something that's formed from common law. The legislator doesn't like, going back to England, where we got most of our laws from, originally at least. They don't like entities, or I should say properties, being in trust indefinitely. Okay, there's all of this back and forth between the king and the legislator and landowners over time, because as you know, land and property was how we held value for centuries and centuries and centuries. Nowadays, not so much. Yeah, property still has value. We have other asset classes like stocks and bonds and so on, where we can hold value. Back then, it was just property. Just property. That's how you acquired wealth. So the king wants to be able to tax, right? They want to be able to control property by saying, oh, well, if you don't contribute 15 people from your land to my army so I can go get more land and go get more wealth, then I can't do that, then I'm in trouble, so I need to be able to control you. So he's going to say, well, you can't put these things in trust indefinitely. So hence the rule against perpetuities was formed. And that just says that a property can't be in this sort of land trust for an indefinite period of time. And what's eventually resulted is a life in being plus 21 years. So in other words, you've got to identify a person who lives today, including an unborn person, and add 21 years to that life, and that's the termination point for the trust, unless it's amended.
I think you might be headed there, Brandon. I'm not sure if I'm the only one, but I think that understanding sort of what the purpose or benefit of a trust might help us to hang something on that, on this, or did you already say not blanked out?
We're getting there. We have a whole list of benefits of a trust. That's the meat of the presentation.
Okay.
Okay. So again, I don't want to get stuck in the weeds here. People have questions about this. I just was trying to touch on it very, very briefly. For the sort of legal scholars out there who might appreciate some of this background, it's helpful when you're trying to talk to a title company or trustee to know some of the parameters, what you're dealing with, some of the pitfalls and snags. Question back there.
Can you form another trust and take one and put it into it so it actually does continue on past that person's lifetime?
Brian, repeat the question too.
Yeah, I believe the question was, can you put a land trust into another trust so that it continues on? The answer is yes and no. We're going to get to a strategy here in a little bit to protect liability and your exposure of stacking, of putting trust in trust. But for purposes of the original land trust, it's going to expire at life of being plus 21 years. So it doesn't matter that you put it into a multi-tiered sort of structure. You're still going to have to amend it. Now, as a practical matter, guys, and I don't want to get stuck on this, we could spend a whole weekend, literally, 2 or 3 days on land trusts, and I've got an hour to try to condense all this down. I don't want to get stuck in the weeds, but what you do as a practical matter with this life and being plus 21 years thing is no one really cares, right, until someone's challenging it in court, and you just amend the trust. That's all you do, okay? And if you find that a trust is really continuing for that long, then you just sign a piece of paper that says the trust is amended, even after the fact. Okay? So, it's something that you want to make sure you're wary of. Also, I will say that most land trusts, for your purposes, are going to be for flips, right? So you're not going to hold on to it for very long. So it's going to be one trust, one property. Property goes into the trust. And you hear me talk about the trust as if it's an entity. Just bear with me. That's how we talk about it. But again, it's not an entity. And then you're done, right? And then the trust is terminated. So practical matter, probably not going to apply too much. Statute of uses, this is important. Maryland does require, for common law purposes, something more for the trustee to do than just hold bare minimum title. They actually do want some sort of minimum level of responsibility for the trustee to take on. So that's a matter of drafting your land trust agreement. So again, this is just a flag of that point. Very, 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 very important. A land trust, think about a land trust, I think about land trust, you should think about land trust, like an LLC. Okay? Even though it's not an entity, think about it like an LLC, where you've got a manager, which is the trustee, you've got beneficial owners, which is akin to the membership interest in an LLC. That's how you think about it. Importantly though, the LLC has limited liability. Land trust does not. And that's the biggest distinction. And that's the biggest, most important thing. You come out of this talk, make sure you remember it does not have limited liability. There are ways that we're going to talk about to shield yourself to get over that hurdle, but that is the most important distinction between land trust and LLC. Okay, so going to your point here, what is the whole point of land trust? Why do I want to use them? What the heck are you telling me today, Brian? One of the most important things is privacy. Okay, land trust, as I said already before, is they're under the radar screen. The beneficial interest isn't recorded anywhere. Okay, the deed obviously is on public record. The deed just says Joe Schmo, trustee for XYZ Land Trust, but the beneficial interest is not recorded. The land trust agreement, not recorded. It's not a public document. In the land trust agreement, you're going to say to the trustee, you have civil liability if you disclose the beneficial owner of this land trust. In other words, you're going to tell the trustee you can't tell anybody who the beneficial owner is. Okay? There's huge, huge benefits to that privacy component. Let's say you've got 12 or 15 properties. You're going to put each property in a different land trust, right? Doesn't cost anything to form these land trusts. We already talked about that. If you have a couple of different trustees, you don't want the same trustee on all of your land trusts. Because if a litigator is going to sue you, they're going to do some research. They're going to say, does this LLC have 10 or 12 properties? Does this person have 10 or 12 properties? Because we're going to try to attach a judgment to their other assets, right? You have a couple of different trustees, they're never going to find these other properties. Right? They're not going to find them. There's just going to be different trustees out there. Right? Okay? So that's an optics thing. Walt Disney. We're actually going to Disney World next week. So first time, my kids are 6 and 7. They're super duper excited. So I had to put this on this presentation. Walt Disney put together all of that land. I mean, it's massive. There's, I don't know exactly, hundreds of acres. It's huge. Just Animal Kingdom is huge. He put it together using land trusts. Why? Because what happens to the price of land when all the adjacent landowners know that you're trying to buy every single one of their parcels?
It all goes up.
If you use a land trust and a trustee, they're not going to know. Okay. Obviously, you're not dealing with tenants, neighbors, buyers, etc., agents, if you're using a land trust. Okay, it's privacy. You don't have to worry about tenants and toilets if you've got a good, management company. The tenant isn't going to go call you. You're going to call first management company, and maybe they'll figure out who the trustee is. Okay. Also, very, very important. It's a personal property interest, right? How many people have gotten to a closing table and discovered they can't close because there's some judgment against the seller? Some lien against the seller in some capacity. Not a problem with land trusts. You don't have equitable interest as a beneficial owner, equitable title. So that lien that attaches to you doesn't attach to the property.
Wow.
You follow that?
No.
Say it again.
Well, it is good, but I want you to follow it too. Okay, so if I'm a seller, I hold 123 Main Street in my personal name. Okay, I've been a bad boy. I have a judgment outstanding against me, and I haven't paid it. Okay, it's for $10,000. I can't sell this 123 Main Street property that I own, that I now want to sell, and I've got under contract, unless I pay that judgment. In Maryland, that judgment automatically attaches to my property. I'm holding it personally. Okay, I can't sell the property unless I pay the $10,000. I don't really feel like paying the $10,000. The plaintiff is a deadbeat, and I really disagree with the court, so we're appealing it. Whatever. Okay. if I own the property through the land trust, I own the beneficial interest. The beneficial interest is personal property, right? Those judgments only attach to a legal or equitable interest in properties. Therefore, I can sell that property that I own in land trust and get my proceeds out without paying the judgment. Okay? Good stuff, good stuff, good stuff. Death, bankruptcy, divorce, same sort of things. You're not going to have as big of an issue. If the seller dies, the land trust still survives, right? Bankruptcy, you're going to have to get probably an authorization from the trustee, the bankruptcy trustee, if the person whose beneficial interest is now in bankruptcy, because that personal property interest that they own is in the bankruptcy estate, but it's a lot easier than getting the whole property out of the estate.
Going back to that lien situation, can you put it in trust after the lien?
No,
It's gotta be before.
Yeah, it attaches. Yeah, the question was, if I have a judgment against me, I own 123 Main Street personally, and I get a judgment against me, and I say, screw you court, screw you plaintiff, I'm putting this property in a land trust, and you're not going to touch it after the judgment is entered. No, unfortunately, it doesn't work. That judgment is going to stick with the property. The title company is going to do a title search back 60 years. It's going to pick me up as being in a chain of title personally, and having that judgment attached to me personally while I own the property, and it's going to encumber the title. That's right. Yeah.
Just to add on to that, can you transfer your property if you're not in trouble or anything? You take LLC to a land trust.
Yes, you can. Yes, you can. Absolutely. The question was, can you transfer, if you're not in any sort of litigation, can you transfer your property that's currently owned by you personally or in an LLC to a land trust? And the answer is absolutely yes. Yeah.
What if you have a judgment against you and you buy property after the judgment? Can you put it in the land trust and you buy it and it not be affected by the
New property. So you've got a judgment right now against you right now, but you're wanting to buy a property through the land trust. No problem. You can do it. Yeah, it's not going to show up.
And I think I heard you say, would you repeat, if you are selling a property through a land trust, what you don't have to do and what that means?
Okay, so, last time, if you own a property, so you own the beneficial interest in a land trust, you have a judgment against you.
No, I'm not talking about that.
Okay, I'm sorry.
If you are, you're flipping the property, you set the property up in a land trust. Now you want to sell, somebody wants to buy that property. How does that look? Is it just going through a HUD one and going through
Yes.
settlement and all that?
Yes, yeah. Yeah, the trustee would be the seller. So, Joe Schmo, trustee, as trustee for the land trust, 123 Main Street Land Trust,
Okay,
on the seller side.
okay, I thought you were
Just
saying
like a
something
regular
about
transaction.
taxes and the stamps and all that.
We'll get to the transfer recordation tax exemption in a little bit.
Oh,
You jump ahead of that, you're a smart guy. Okay, all right. Avoid probate and estate planning. Okay, so you can provide, this is, land trusts are traditional, trusts in general, inter vivos trusts are in general used for estate planning. You know this, right? You can avoid probate because you can designate your successor interest, a successor beneficiary of the trust. Works the same way in a land trust. Okay, so you don't have to go through probate. That saves probate costs. That saves those properties becoming part of the public record. If you're looking to transfer, those properties from, as a legacy matter. Okay, you're looking to avoid being in the public spotlight. If you're, like Charles, and you're absolutely a billionaire. Okay, estate planning, the same. Okay, so and ancillary probate. Ancillary probate is when you live, for example, in Maryland, but you own a property in Virginia or DC or any other state, and you die. That other state, because the property is located in their jurisdiction, is going to want to set up their separate, independent probate because the property is located in their state. However, so you're going to incur those costs, you're going to be inconvenienced, etc. However, through a land trust When you die, you own the beneficial interest in the land trust. That's personal property, not subject to probate in the other state. Good stuff. Okay, more benefits, more benefits. If you've got a farm or a big development, right? You've got 200 acres that you're developing, or it's a big farm, and these sort of things pass right through the family, and you want to keep it within the family. Whatever. It's a complicated, nuanced sort of situation. You've got a bunch of heirs that you're going to disagree about how to use the property. Frequently, what happens is this thing called partition, where the heirs can't agree. Some want to sell because they want the money. Other people want to, hold on to it because they want to see more appreciation, or it's a homestead, whatever. Okay. The people who want to sell are going to sue in court and for partition. The court's going to order a sale, and you're going to get a lot less money, right? Because it's court-ordered sale, it's partition. Unfortunately, everybody loses in that sort of situation. With a land trust, you can't partition personal property. It's only with legal or equitable interest. Okay, so you can't do that. So if you're trying to estate plan a little bit, and you want to keep this property in your family, put it in a land trust, then it's just a little bit better to plan going forward, because you can't get a partition suit. If people are going to sell their interest, their beneficial interest in the land trust, well, they're going to sell their interest, and that's not going to affect the other beneficial owners.
I'm sorry, I'm kind of confused. Can you just go over that one more time?
You bet, absolutely.
But can you speak in like layman terms, because I'm not understanding what you're saying.
I'm sorry. And I apologize. I do talk fast and I do talk legalese. So partition, the concept of partition, that's when you break up a property. Okay? So let's say I die, and Cliff and you and your sister are all heirs of my property. Cliff wants to sell because he wants the money. But you and your sister want to keep the property because it's a homestead. You've had it in your family for generations. You like the house. You want to live there, etc. Okay, so there's a disagreement among the heirs.
Imagine that.
Cliff really wants the money.
Imagine that.
That never happens.
Okay, so what's going to happen in that situation typically is Cliff is going to file a lawsuit in court, and the court is going to order a sale of the property.
If it's not in a land trust.
If it's not in a land trust. Why? Because it's a piece of property. There's no way they can sort of split it up. Cliff can't have this little corner over here of the property while you have the house. It doesn't work like that. Okay, so they're going to partition the property. It's going to sell. Everyone loses. You lose because you don't get to keep the property. Cliff loses because it's going to be a lower sale price, right? It's a court-ordered sale. They're just trying to liquidate the property. Okay, that's the normal way things usually go. With the land trust, though, you're a beneficial owner of the land trust. Your sister's a beneficial owner of the land trust. Cliff is a beneficial owner of the land trust. Cliff can't bring a suit to partition that property because it's a personal property interest, not a real property interest, not an equitable or legal interest. He can sell his personal property, meaning his beneficial interest in the land trust. That's good. He might be able to get. maybe it's a big farm and there's proceeds coming out, or it's a rental property and there's money each month coming out. Great. Sell his interest. Maybe an investor would be interested in that little piece of the property. Great. And then, meantime, you get to keep the property that you want. So it makes it harder. If I know that I've got 3 siblings who don't get along, but I want to keep the property in our family name, it just makes it a little easier to do that.
Yeah, you can cook me dinner and then say, look, let's talk about this.
That's what it turns into. It turns into a family conversation instead of something in court, right?
That's right.
And so you can sell it to them. Cliff could sell his third to them if they wanted to, or
Absolutely.
a private investor.
Right.
Yeah, he could do either of those things. He could do that in a regular situation. He could sell his 1/3 interest in the property anyway, but this just makes it so that he can't force their hand by suing in court.
Does an appraiser set the value of his 1/3? Who sets the value, him or
Or the-
appraiser?
For the personal property interest,
Yeah.
that's market. Market sets it.
So it would be an equal third if his name is
Would
on
know
it.
whatever is designated in the land trust
So
agreement.
that's his designation in the land trust when you, before you pass, set it up.
That's correct. And again, remember, I can change it at any time. So
So it's a little bit different than a will.
when I set it up, I can change it.